May it please Your Honor, I, BILAL AHMAD, student ID 23016708, appear on behalf of Mr. John Lannister in this renewed application for bail, brought under Section 4 of the Bail Act 1976. Your Honor, my client is an unconvicted defendant who has been remanded in custody since his arrest on 20th January 2025. Bail was initially refused by the Magistrates Court on 28th January 2025 due to two concerns, Your Honor. Firstly, that he had no fixed address at the time, and secondly, that there was a risk of further offending. Today, I submit that both these concerns have now been thoroughly addressed and that appropriate and proportionate bail conditions can be imposed to mitigate any remaining risks. In light of these developments and in accordance with the applicable legal and procedural framework, I respectfully invite the court to grant bail. Section 4, subsection 1 of the Bail Act 1976 provides that there is a general presumption in favor of granting bail to a defendant who has not been convicted of an offence. The presumption may be rebutted only if the prosecution establishes substantial grounds under Schedule 1, Part 1 of the Act. Specifically, the prosecution must show one or more of the following: that there are substantial grounds for believing that the defendant, if released on bail, would fail to surrender to custody, commit further offences while on bail, and interfere with witnesses or obstruct the course of justice. Further, under Section 3, subsection 6 of the Act, the court is empowered to impose conditions on bail that are designed to mitigate the relevant risks. The defence submits that this is precisely the appropriate course in the present case. In addition, Your Honour, I would refer to the court to Criminal Procedure Rule 14.2. This rule requires the court to actively manage cases, including bail decisions, in a manner that is fair and proportionate, and in accordance with the overriding objective of justice. The court is therefore under a duty to ensure that the decision reached today reflects both the rights of the accused and the interests of justice. Finally, Your Honour, the court should bear in mind that Article 5, subsection 3 of the European Convention on Human Rights, as incorporated into domestic law by Human Rights Act 1998, that article provides that pre-trial detention should only be used where strictly necessary, and that unconvicted persons should not be subjected to custodial measures unless there is no other viable alternative. It is my respectful submission that such an alternative does exist here. Turning now to the concerns raised at the previous hearing, firstly, the lack of a fixed address. At the time of the initial application, Mr. Lannister did not have a stable accommodation, Your Honour, but that position has now changed. He has secured a confirmed residence at 1 Braun Boulevard, South Shields. He will reside there under the supervision of Mrs. Payne, a long-standing family friend of Mr. John Lannister's. Mrs. Payne has agreed to act as a surety and has provided written confirmation of her support. She is prepared to take responsibility ensuring that Mr. Lannister complies with all of the bail conditions set by this court. Additionally, Mr. Lannister is willing to surrender his passport, submit to electronic monitoring, observe a strict nightly curfew, and report twice weekly to South Shields Police Station. These safeguards are precisely the types of measures envisaged by Section 3, subsection 6, and are more than sufficient to remove any concerns under paragraph 2.1a of Schedule 1. Secondly, the Magistrates Court was concerned about the risk of further offending under paragraph 2.1b. It is important to stress that Mr. Lannister has no conviction for theft, dishonesty, violence, or indeed any offence of similar nature to the one alleged. His only previous convictions are for minor driving-related offences, which are now spent under the Rehabilitation of Offenders Act 1974. There is no suggestion of a pattern, Your Honour, and certainly no history of offences committed while on bail. Furthermore, since the time of remand, Mr. Lannister has secured full-time employment. He has been offered a position as a court operative at the Court of Time, earning £25,000 per annum. This is not a casual arrangement, Your Honour. It is a formal employment arranged by a Mr. Podrick Tollett, a friend of the family. We can provide a written confirmation of the offer if needed. Employment of this nature provides structure, financial stability, and an incentive to comply with all court directions. In our Harrow Crown Court, the High Court confirmed that where conditions such as stable accommodation and full-time employment exist, the presumption in favor of bail should not be displaced unless there is compelling evidence that the conditions would fail to mitigate risk. As to the third ground, interference with witnesses, there is no evidence at all that suggests that Mr. Lannister has attempted to interfere with any witness, nor is there any background that would indicate likelihood of such behavior. The key witnesses in this case are two serving police officers, one Mr. P.C. Mormont and the other P.C. Clegane, and one civilian, Mr. Jamie Stark. Mr. Lannister has not contacted, approached or threatened any of them. To address any lingering concern, the defense is content to accept a strict condition that he must not contact any of the prosecution witnesses, either directly or indirectly. This condition is standard, enforceable and effective. In R.V. Griffiths 1982, the Court of Appeal held that such bail conditions, when properly applied, are capable of managing even serious risks. Your Honour, the court is also invited to consider the current strength of the prosecution's case. The primary evidence linking to Mr. Lannister to the alleged offence comes from the identification made by P.C. Mormont. That officer is now unavailable to give live evidence due to health complications. Moreover, a person matching the description initially provided has since been found deceased, introducing a serious alternative suspect and casting doubt on the reliability of the original identification. As held in R.V. Gray 2003, the strength or weakness of the evidence against a defendant is a relevant and important factor in assessing the need for continued detention. When the evidential foundation weakens, the case for release becomes stronger. I would like the court to also consider the broader circumstances under paragraph 9 of Schedule 1. These include Mr. Lannister's personal character, community ties, and the likelihood that he would comply with any conditions imposed. He is not only a man of previously good character, but is also currently serving as a carer for Miss Payne, who is in poor health following hospitalization. She has no one else to support her. His release would allow him to fulfill a genuine and important humanitarian role. In R.V. Moran 1987, the court acknowledged that a defendant's role as a carer can be a material factor in favor of bail. And to address any foreseeable concerns, the defense proposes that the following bail conditions under Section 3.6 of the Act, Bail Act 1976, should be applied. As we are willing to comply with Mr. Lannister staying at 1 Brown Boulevard, South Shields. He will be also following a curfew from 8 p.m. to 6 a.m. and he is willing to be monitored electronically. He is willing to report twice weekly to the local police stations, and he's willing to surrender his passport, which will prohibit him from traveling, and he is also willing to go to a no contact clause with prosecution witnesses. These conditions are comprehensive and proportionate. They offer effective safeguards against each statutory risks. Your Honour, the court is invited to exercise its discretion to grant bail in accordance with the legal framework set out. The statutory presumption under Section 4 remains. The concerns which originally led to refusal have been resolved or mitigated. The evidential foundation of the case has weakened. There is no history of non-compliance, no risk of the interference, and bail conditions are available to protect the public and the integrity of the proceedings. In these circumstances, continued detention would not be justified and would be contrary to both domestic statute and the United Kingdom's obligations under Article 5, subsection 3 of the ECHR. Your Honour, if you have any question now.
Could you outline the grounds upon which bail was originally refused and explain how those concerns have since been addressed?
Certainly, Your Honor. As previously mentioned, bail was previously refused due to the absence of a fixed address and concerns about the potential for further offending. Both these issues have now been fully addressed. The defendant has secured verified accommodation under supervision and has obtained legitimate employment, reducing the risk of reoffending and demonstrating stability.
What provision is in place should the proposed surety, Mrs. Payne, become unable to fulfill her supervisory role during the defendant's bail period?
Your Honor, should that situation arise, the defense would immediately inform the court and propose amended bail terms or seek to nominate an alternative surety. The defendant remains committed to full compliance with any conditions imposed by the court.